Hi, I'm Jennifer Brown, editor of Canadian Lawyer in-house magazine. I'm joined today by Nikiforos, Iatrou, and Scott McGrath of Weirfolds LLP. In this edition of the Weirfolds Quiz, we're looking at how Canada's competition laws are even more relevant than ever before. Investors looking to make an investment in Canada really have to take a close look at their actions before going ahead. Nikki, if I'm in-house counsel with a small mining company, say in the uranium market, and I want to merge with another small player, is the Competition Bureau likely to pay attention to the proposed deal?
As of January 2013, mergers worth less than $80 million aren't notifiable under Canada's Competition Act. That being said, recently we've seen that size isn't necessarily the determinative factor. The Commissioner of Competition can challenge any merger regardless of size for up to a year after that deal is closed. Indeed, it recently challenged one of these non-notifiable transactions in a case called the Commissioner of Competition versus CCS. That deal was only worth $6.1 million, but that didn't stop the commissioner from successfully challenging the deal.
What if two or more mining companies want to join forces to set prices for export of uranium? Is that allowed?
Well, that gets you into a cartel situation, and cartels generally are not permitted under Canadian law. But there is an exception, subject to certain conditions, for export cartels that are aimed just at the export of product from Canada. A member of an export cartel, though, is going to want to make sure that they're really careful about it, that they run everything through an independent third party, that they don't exchange any confidential information between the members of the cartel, because they could still be offside Canadian antitrust legislation.
And what if a foreign company is looking to take over a domestic company? How is foreign investment being considered these days?
The Competition Act still applies, even in the case of a foreign takeover. But when you're dealing with foreign investment, you also have to think of the Investment Canada Act, which requires you to get the permission of the Minister of Industry for these kinds of deals. Now, the financial thresholds there vary depending on the industry and the country of origin of the investor, but typically, to use your mining example, a deal like that would only attract attention if it was worth over $330 million.
Okay, thank you. For a more in-depth look at foreign investment and Canada's competition laws, please have a look at the January issue of Canadian Lawyer in-house magazine.